Our first speaker today is Roderick Gordon from Gordon McGrath Attorneys-at-law. Let me just go to my notes here. Roderick Gordon is an experienced attorney who has advised clients on technology-related legal issues over the last 15 years. His expertise lies in intellectual property law and regulatory compliance. Roderick has had presentations at various international events, including Brazil and Senegal, where he was invited by the World Intellectual Property Office to speak about IP rights. He has advised regulators and has assisted with the review and amendment of legislation, as well as the interpretation of legislation in matters before the court. We are very fortunate to have Roderick with us this morning. Roderick Gordon, ladies and gentlemen, over to you.
Thank you, Anne-Marie. Good morning to everyone who has joined. Good morning to the panelists. We're really grateful that you all would take the time in the beginning of your day to join us. So we will try to enlighten you as to what are the rules of digital engagement. What is data protection about? Anne-Marie has spoken quite pointedly to the fact that both our partners in the EU as well as the United States have similar regulations. So part of what our Act seeks to do is to ensure that we are not just protecting data of our data subjects that may be present in Jamaica, but also data that may be processed in Jamaica for data subjects who are not Jamaicans. And we'll come to that definition a little later, but I think it's important to note. We are going through, some would say we are well into the fourth industrial revolution, this information technology age, this e-commerce age. And what we have to do is to recalibrate how we think. We have already recalibrated how we interact with our customers, but we now have to recalibrate how we think about our customers and their data. Data is you know, it's lighter than tissue paper. It's out there. A lot of us don't think twice about sharing our data, about where our data goes. And what the Data Protection Act is doing is ensuring now that everyone who deals with personal data, of the definition is called data subjects, understand the responsibilities and obligations they have. And if you fail with those obligations, there are fines, there are penalties, and you can also be open to personal suit from someone who feels you've breached the rights that they have to their data. So let's start with our disclaimer. This presentation has been prepared by Gordon McGrath Attorneys-at-law for informational purposes only and does not constitute legal advice. This presentation shall not be construed as an offer to represent you, nor is it intended to create, nor shall the receipt of such information constitute an attorney-client relationship. All right, so I reserve pursuant to the Copyright Act. All right, so it wouldn't be good lawyers if we didn't say that. So let's look now at the objective of our Data Protection Act 2020. This act has been passed, so it is in fact law currently in Jamaica, but it has not yet taken effect. So the actual commencement of the act has not yet begun in terms of it applying to businesses and people who process data, but we'll speak a little more about that later. So what the act seeks to do is to define the general principles for the treatment of personal data relating to an individual. It provides for the transparent oversight, and it will enable both the public and private sectors to strengthen the protection of personal data. I would remind everyone that certainly for Jamaica, you have a constitutional right to privacy. Okay, so in our Charter of Fundamental Rights and Freedoms, you now have the right to privacy, not just when you're at home, but privacy from your data, okay? And so our standards actually are a little higher than even in some of the United States territories, the specific states, because they do not have a constitutional right to privacy as we do. The EU Gdpr, as Anne-Marie in her introduction indicated, we agreed to a particular treaty, the EPA, and that GDPR, which is what the standard and the regime is called, also seeks to ensure that we protect how we deal with the personal data of citizens of the EU. Okay, so in 2008, along with CARIFORUM states, we signed the CARIFORUM EU Partnership Agreement. And that obliges us to adopt adequate safeguards of the protection and privacy, fundamental rights, and the freedom of individuals, in particular with regard to the transfer of personal data. I'm going to read quickly from the Memorandum of Objects and Reasons, which was delivered when this act was passed in Parliament. A decision has been taken to enact legislation in order to secure confidentiality of personal data, which may be in the possession of entities, including government authorities, and to provide for the rights of individuals in relation to their personal data in the possession of those entities. This bill seeks to give effect to that decision and, among other things, establishes the office of an Information Commissioner, charged with the responsibility of overseeing the manner in which personal data in the possession of entities is handled. The EPA, which is the Economic Partnership Agreement, which we entered into in 2008, requires the signatories to establish appropriate legal and regulatory regimes in line with existing high international standards, with a view to ensuring adequate level of protection of individuals with regard to the processing of personal data. So everyone under the EPA has to ensure that they're protecting data for all the member states and their citizens. So I think it's really important for us to understand that why we're saying these are rules of digital engagement is it's not just engaging with your customers who you may deal with online from our shores. It is also for people who are outside of Jamaica. All right, so the regulator is the Information Commissioner. Very interesting title. Not unusual. It's a title that has been used under the GDPR as well. And this person is not someone who is under the constabulary force. It is an office which is going to be headed by someone called the Information Commissioner. And this office is charged with, amongst other things, monitoring compliance with the Act. This is the office that businesses and anyone dealing with data as a data controller will have to register with, and we will come to that shortly. Okay, let's look at a summary of key definitions. And I will warn you, the Act is very long. It is currently well over 70 sections. The regulations have not yet been promulgated. I expect the regulations will be another 50 to 100 different sections of regulations. So it's a lot of material, and what we're really trying to do this morning is to really give you the framework and give you the key data points, pardon the pun, that we think will give you a better understanding of the framework, a better understanding of some of the obligations you'd have to face so you can prepare for the coming of the Data Protection Act. So first, a data subject is a named or identifiable individual who is a subject of personal data. And that is important. Named or identifiable, as you know, you can share data which is identifiable to you personally, which does not necessarily include your name. So you may share other personal data such as your date of birth, your email address, your home address, other personal data points that when they're pulled together, they identify you as a data subject, which doesn't necessarily include your name. Personal data under the Act is defined as any information from which a living individual or an individual deceased for less than 30 years could be identified from. So as a data controller, you would still have the obligation to maintain the data protection standards for someone who has died, who may have been a client of yours, a customer of yours for less than 30 years from the implementation of this Act. And that is worth noting. Obviously, hospitals, medical facilities will have to pay keen attention to this. Direct marketing is defined as promoting or offering to supply in the ordinary course of business any goods or services or requesting a donation of any kind for any reason. Now, why is this important? That probably is the bread and butter that most businesses currently do on a day-to-day basis with existing customers. Okay, so once you are reaching out to your customers at all by email or through any data that has been provided to you, then you are processing data and you fall under the Act. So who is a data controller? Well, a data controller, ladies and gentlemen, is you. It's any person or public authority who determines the purpose and manner in which personal data is processed. So once you have the consent of a data subject to take their personal data, once you determine how that data is processed, you are the data controller. Anyone who runs a business who collects that personal data is a data controller. What is processing? Processing covers a wide range of operations performed on personal data. It includes the collection of that data, the recording of that data, the organization, the structuring of that data, and it includes the storage of that data. Storage is important, obviously, because some of us use cloud storage. You may decide to use Dropbox or any of these consumer level storage options, and the data may be stored overseas. Well, you have to ensure that it is stored appropriately and that the standards that it is being stored under meet our Data Protection Act. So that's very important, and I'm sure the Info Exchange team will speak a bit on that and better options that may be present that you may wish to consider. All right, so how far does this act reach? The act applies to data controllers established in Jamaica. Okay, so all of us, okay, we do business in Jamaica, our businesses, our offices are here. We are entities that exist in Jamaica. But it also applies to data controllers that are not established in Jamaica. Okay, the act applies if that data controller, I don't know, Amazon, maybe Google, one, uses equipment in Jamaica for processing personal data. Two, processes data of data subjects in Jamaica in order to offer products or services. Or three, monitors behavior of data subjects taking place in Jamaica. And when I read that one, I immediately remembered Cambridge Analytica. I don't know how many of you may have watched the documentary, The Great Hack. That's on Netflix, but one of the more revealing parts of that documentary was the work Cambridge Analytica did in Trinidad and Tobago. And Trinidad are taking legal steps to bring the alleged perpetrators to book in Trinidad. But just the fact that Cambridge allegedly did a service for an entity in Trinidad by monitoring behavior of data subjects in Trinidad. If Trinidad had our similar act, it would bring them under the purview of this act. So if a Cambridge Analytica did that work in Jamaica, and they monitored behavior of data subjects here, they would have to oblige and ensure that they were complying with the standards and obligations under this act. All right, so what are the key obligations of data controllers? One, registration. So you have to register with the Information Commissioner before processing personal data. So that's a pretty huge obligation because, of course, if you don't, there is a fine. Some data controllers will have to appoint appropriately qualified data protection officer. A data protection officer effectively is very similar to an internal auditor. Okay, so what this data protection officer is to do is to ensure that when you've put your governance, your policies in place, they assess it, they ensure and say, okay, we believe it is in keeping with your obligations under the Data Protection Act. In some instances, when you may have a breach or you may have some challenge under the Act, it is the data protection officer who you would first speak to say, listen, this has happened. This is how I've handled it. I think it's fine. And the data protection officer would actually have, in some instances, the right to say, okay, I think that's good. We don't need to now report to Information Commissioner. So that's a very interesting new person that is being included in our landscape, and it really brings home the fact that once you're doing business digitally now, there's this whole other regime, these standards that you need to ensure you put in place. All right, and of course, the analogy with internal audit continues. So on an annual basis, you have to do an impact assessment. And this is an annual report that you as a data controller must submit to the Information Commissioner. The Act, of course, sets out data protection standards. And I will read very quickly from an article. Let me give credit to Professor Graham Greenleaf. He's a professor from the University of a university in Australia, UNSW. And he wrote an article in late 2020 on our Data Protection Act. And in conclusion, he says this: Jamaica's Data Protection Act is a remarkably strong post-GDPR data privacy law. Of the nearly 20 features of the EU's GDPR that are relevant to countries outside the EU and are stronger than the 1995 Data Protection Directive, only a handful are missing from explicit inclusion in this law. Data protection by design and default, demonstrable accountability of controllers, etc. The exemptions from the Act may prove to be unreasonably broad, is a view he has. It remains to be seen whether fines of up to 4% of corporate turnover will genuinely be dissuasive when administered by courts, and whether significant compensation awards will be made. Jamaica's law joins in 2019 Barbados law, which it shares many features as a strongly GDPR influenced law in the Caribbean. However, the US 50,000 limit on fines in Barbados means that Jamaica has a potentially much stronger law. If the data protection authorities of these two jurisdictions actively enforce their laws, data privacy may take on a different meaning in the Caribbean. So, from an academic point of view, our Act has received a very strong vote of confidence in what it intends to achieve. And I think that's important to note, because what it does mean is that the regulation is going to be pretty thorough. All right, so can we look quickly at some key data protection standards? So obviously, you must process the data fairly and lawfully. You must process that data, you must obtain the data, beg your pardon, for a specified purpose. So you need to indicate what that purpose is. The data must be accurate and kept up to date. The data must not be kept longer than necessary and must be disposed of in accordance with the regulations. Well, that's what the Act says. We don't yet have the regulations, but I'm sure the regulations will make very clear how you are to dispose of that data. The data must be processed in accordance with the protection standards. Very important. It must be processed with appropriate technical and organizational measures, and transfer of the data outside of Jamaica is prohibited unless adequate levels of protection are used. So you see that the standards to which you are asked to meet are both significant, and they are going to be based on what is considered adequate, what is considered enough. It's not just a matter of you saying, well, we have firewalls on our laptops. We don't store data on laptops. The data is stored just on our central drive in the office, etc. You now have to put in place policies, how you deal with data, how you protect data. You have to look at how you get the data from your customers. You have to get explicit consent, and you have to explain to your customers, to your data subjects, what you're intending to do with their data. All right, so the Act in a number of different sections deals with fines where you do not comply. It deals with offenses which you can fall foul of if you do not do a particular obligation under the Act. And as you heard from Professor Greenleaf, there is a section in our Act which could find a company or body corporate liable to a maximum fine of 4% of its annual gross worldwide turnover for the preceding tax year. So that's pretty significant. And, you know, this is part of why we believe that we need to begin now in educating and in communicating with data controllers, potential data controllers, existing data controllers, as to how you're going to seek to comply with this act and how you're going to get your IT infrastructure up to date and adequate to deal with the significant challenges you're going to have in complying with the Data Protection Act. All right, so we've looked globally, and we want to just share with you some scenarios that we've seen with the GDPR and other regimes in action, so we can get a sense of what we may see coming once our act goes into force. Okay, in Germany, in 2019, Google was fined 50 million euro for failing to comply with the GDPR's requirements on transparency, adequacy, and consent, relating particularly to certain ad personalization. So I'm sure most of us are familiar. A number of websites you may click on, you subscribe to marketing newsletter from Macy's or whichever company, and they have a number of boxes they ask you to check. Do you agree to share this? Do you agree to share that, etc.? In this particular case, what happened is that the committee that reviewed the complaint found that the consent from those checkboxes was not validly obtained for two reasons. The first, the user's consent was not sufficiently informed. So when they looked at what the user would have read to give their consent, they felt that it was not a sufficient basis that the company should feel comfortable that the customer understood or the user understood the consent they were granting. Second, the user's consent was neither specific nor unambiguous. So, you know, that's a pretty decent fine that you would have to face just from a point of view of not ensuring that you were clear, you were specific and unambiguous in the consent you were asking for and what that consent was being given to do. Okay, so that's very important. The next one is, and we just have a quick comparison so you can see what our act looks like compared to the GDPR. So our act says any informed, specific, unequivocal, freely given expression of will which the data subject agrees to the processing of that data subject's personal data. Okay, and you see the language in the GDPR is really very similar. Any freely given, specific, informed, and unambiguous. And we say informed, specific, unequivocal. So the Google example would absolutely obtain here if you're not careful enough to ensure that you do this properly. Our act also says that informed means at the time in question, the data subject is informed about how the personal data will be processed, including the purpose of which the data will be used and the class of persons to whom the personal data may be transferred. Okay, so it will be very important that you put in place good policies, but also that you review your intake documentation, your intake methodology, so that you are gaining the specific consent when you are asking for data subjects data. Right, so the next one was a security breach example, and in December 2020, the Scottish Environmental Protection Agency suffered a major cyber attack. The information stolen from the agency was subsequently published online illegally. Following the attack, the SPA announced we immediately enacted our business continuity arrangements and took immediate action to limit the impact of the cyber attack, notifying relevant authorities, including the Scottish Government, Police Scotland, the National Cyber Security Centre, and the Information Commissioner's Office, with whom we continue to work. this is important because you will understand that if you have any type of cyber attack, any type of breach, you have to report it to the Information Commissioner. Depending on the level of breach, you may also have to report it to other government authorities. We do have a Cyber Crimes Act. Most of you are probably aware. So if you can just go to the next slide. Great. So the data controller under our Act, section 21(3)(5), the data controller must report to the Information Commissioner any security breach which affects or may affect personal data within 72 hours after having become aware of it, as the case may be. So you have 72 hours within which to report to the Information Commissioner that there has been a breach which affects or may affect personal data. The may affect is important, because you may see a breach that has occurred, and based on your review, you may say, okay, I don't think it's going to affect any of my customers, any of the users, but if the possibility remains that it could affect them, you have that obligation, okay? Of course, it goes without saying that the data controller must also notify each data subject whose personal data is affected by the breach. So this is why you see in other jurisdictions very often, where there are cyber attacks or breaches of that nature, the companies put public statements out. Very often, they have, maybe 100,000 up to 1 million customers that may have been affected by such a breach. And it's just more practical for them to publish in various media that they have suffered a breach and they're taking the various steps. Some jurisdictions actually do ask them to make sure they make a public announcement as well, and we may see that in our regulations. And you see that we are mirroring pretty similarly the GDPR regulations there. One of the reasons why this is the case is that if we have obligations under the GDPR, you want to ensure that we are putting those obligations in our national legislation as well. So you don't have to be constantly looking to both regimes to say, okay, how much time under GDPR do I have? How much time on the Data Protection Act? Why? Hotels, for example, a number of you, most of your guests are not, well, I shouldn't say most, but probably over 365 year, more than half of your guests are not Jamaican. So you have to be concerned about how you're complying with GDPR and other legislation. Okay, the next example is technical and organizational measures. So internal structure, policy, methods. In 2019, Bulgaria's Data Protection Authority issued a 5.1 million fine to the country's National Revenue Agency for violations of the GDPR. Their authority, the CPNC, found that the agency failed to implement appropriate technical and organizational measures, resulting in unauthorized access and disclosure of names, PINs, and addresses of Bulgarian citizens, telephones, email addresses, and other personal information. Okay, and then under our Act, again, we have the requirement, you must ensure that appropriate technical and organizational measures are implemented against unauthorized processing, accidental loss, destruction, or damage to personal data. The data controller must ensure that its agents and employees who have access to the personal data are aware and comply with these measures. Some of us may have seen the news last week, one of the reports from our Auditor General, which is very interesting. A number of the issues that the Auditor General raised in their report relating to PICA, which is the next slide. So the Auditor General found that our PICA, there were some discrepancies with regards to their technical and organizational measures. PICA failed to manage the risk of unauthorized disclosure and misuse of access rights. They failed to provide confidentiality or non-disclosure agreements on various occasions, and they failed to enforce the agency's password policy in some circumstances. This was actually very insightful and timely because these discrepancies were not found as breaches of the Data Protection Act, but you will see immediately that they all would fall under various sections of the Data Protection Act as standards and obligations that you should meet. So it's a good heads up for PICA and other businesses and agencies that you really need to look at your policies dealing with confidentiality in terms of non-disclosures with your employees, how you deal with password policies, who you give access to personal data, to sensitive data. So in wrapping up, there are a couple of things we'd like to emphasize. One, you want to confirm whether your business needs to comply with the DPA. Second, you want to assess your data processing activities and obligations and how they fall under the DPA. You want to make sure that you have the relevant agreements in place as between you, customer, as between you, your team members, your employees, service providers who may touch and process your data. And so you have to develop proper policies and governance dealing specifically with the data and data protection. You may need to appoint a data protection officer. You will need to know what to do if there is a breach. You need to have internal policies that deal with what do I do in the case of a breach, and you need to put in place the requisite information streams so that the Information Commissioner hears within 72 hours, but obviously as soon as possible, and any other service providers who may work with you to protect your data, to protect your IT infrastructure, so that you can cauterize that breach as much as possible. A lot of the penalties and fines look at what you do when these things occur. Are your policies strong enough, and how did you act? Okay, so it's really important that you ensure that you act in a timely manner. Okay, thank you. I think we've covered a lot of material, and as I said, what we wanted to do this morning is to give you a pretty substantial introduction to what the regime looks like. I think a question may come: when is the act going to take effect? I can say no, I don't think there is an official date that has been announced. However, I think late last year, the relevant ministry advertised, I think, for over 25 posts of jobs, positions that will be within the Office of the Information Commissioner. I have it on pretty good authority that the physical office is just about ready to be occupied. So I would expect that within this financial year, public sector financial year, we should see the commencement of this act. The act provides a short space of time within which you have a grace period to show full compliance. But I really think that we all have to look now at our infrastructure. We have been pushed, those of us who were slow to join the fourth industrial revolution have been pushed because of COVID, because of work from home. And so it is really important that you get yourselves fully informed as to what you need to do under this act and how you need to treat your data subjects, how you need to treat data that is shared with you, which belongs to the people who share it with you. Just because they give it to you doesn't mean that now you have co-ownership. What it means is you are getting a particular consent to use it in a particular way. And you see that the act specifically says, not only should the consent you request be unequivocal and clear, but you should also indicate how you intend to use the data. So it is really, pretty strong. I want to make a final point on the fact that data subjects, individuals, can seek to get compensation under the act. So in addition to the fines and penalties, there is a specific provision which makes clear that if a data subject has suffered damage because of a breach or contravention of the act, or if a data subject is distressed, which can be, emotional distress because of contravention of the act in terms of how the data has been used, they can bring a civil lawsuit against the data controller to right what they perceive to be that wrong. So it's not just you, having to comply with these standards that an information commissioner will regulate. It's also you dealing with the data of this data subject properly, with respect and with consent. Okay, thank you.
Well, that was a lot, a little frightening, if I might say so, because basically what you're saying, Roderick, is that the information that we're getting on our customers doesn't belong to us.
That's
and
right.
We have to seek permission from them if we're going to use it in any way, shape, or form. And if some unscrupulous person decides to steal that information, or if we use it erroneously in some way, the business owner, operator, IT manager can be held personally liable.
That's actually correct. Yes, the Act does provide for that.
On top of the fact that they're going to get 4% of the worldwide turnover, annual turnover. And is there possible jail term connected to all of this?
There is. I mean, I didn't want to sound like, you know, Captain Doom this morning and go into all of that. But yes, there are significant fines for companies, for the people who actually handle the data. There are breaches and offenses where the specific person, if the company has policies in place, but the person who is charged with the responsibility doesn't handle it properly and doesn't do what they're to do, they can be charged personally. So yes, there are very significant and personal penalties. It's not just a 9 to 5, well, I was at work and, you know, I'm gone home, so the company has to deal with it now. No.
All right. So let us move on to the question and answer. We have quite a few questions here already. I'm going to, I apologize. I should have introduced Dene Richards and Carrie-Ann Kudo, who are members of our team, and they will be posing the questions, verbalizing the questions. Dene, do you have any questions? Can you just start with the first question?
Hi, good morning, everyone. Yes, we have quite a few questions coming in. Our first question, however, comes from Michael. He asks, do data subjects include your employees?
Right, it's a good question. So yes, the answer would be yes. If the data subject provides personal information, personal data to you, then yes, you have an obligation to let them know how you're going to use their data if you're going to share it. There are exemptions under the Act, and I think that's a good point and place to mention. So if you are processing data in certain circumstances for the purpose of work, so that would be an example, then while the data is a the data provided by your employee would qualify as a data subject. If you are processing it solely for the purpose of what you have to do internally and you're not sharing it outside, then you have a qualified exemption. But that employee, if there were a breach and they felt that they were affected by that breach, would still have their rights under the DPA.
Okay, Carrie?
We have another question from Candice. Under what circumstances or conditions would a data controller be required to appoint a data protection officer?
Great question. So Section 20, subsection 6 speaks to the data controllers who are currently required to appoint a data protection officer. Public authorities, data controllers who process or intend to process sensitive personal data or data relating to criminal convictions. And quickly, I can tell you, sensitive personal data includes gender, it includes any health issues, matters that you certainly would not be in the ordinary course of business sharing. Data controllers who process personal data on a large scale, or any other data controllers prescribed by the commissioner. So there could be another set of data controllers prescribed by the commissioner, who would have to appoint a data protection officer. But currently, public authorities, data controllers who process sensitive personal data or data relating to criminal convictions, and data controllers who process personal data on a large scale.
Okay, moving quickly along, there are two questions from two separate persons, but I'm just going to pose them together. From Christopher, he says, where can I get access to the Data Protection Act? And
Right.
Debbie's asking, does the act have any teeth?
Right, so I would suggest, if Christopher, if you go to the Parliament website or the Ministry of Science website, you should find the Data Protection Act there that you can download. And I will tell you quickly, Debbie, yes, it has teeth. Let me tell you quickly some of the fines. You have fines of 2 million, you have fines up to 4% of turnover. You have enforcement notices, which the Information Commissioner is able to issue. So let us say that a data subject, a customer of yours, feels that you have misused their data or are unhappy with how you've used their data. They can make a complaint to the Information Commissioner. The Information Commissioner evaluates it and sends an enforcement notice to you, saying you have to provide certain information. If you don't do it within a certain time, you can be fined and found to be in breach of the act. So I would say to you that it does have a lot of teeth. And in preparing for this presentation and coming across Professor Greenleaf's comparison of the Caribbean laws related to data protection, he has said that the Jamaican law is the most rigorous in terms of teeth, because we have gone higher than the Barbados Act, which is a maximum fine of $50,000 US. We have adopted this 4% of gross annual turnover. So let's say, for whatever reason, someone in Jamaica decided to complain that Amazon had used their data in a particular way. And let's use quickly the example of Cambridge Analytica, Facebook. So for whatever reason, Amazon has your data and they sell the data set for their customers in Jamaica to someone else, and you start to be bombarded with messaging about your health. So let's say for whatever reason, Amazon is able to, with their data, determine that you have a particular health need, maybe based on your shopping preference and other information you provide. If in fact, you have a complaint about that and our Information Commissioner finds that Amazon was at fault, they could face a fine up to 4% of their gross annual global turnover. So I would say that that is a lot of tea.
Okay, the numbers of questions are racking up, and we are quickly running out of time for this segment. But the good thing about it is that at the very end of all three presentations, we will be going back to these questions. So you know, just hang in there. The questions will get answered. We'll be staying here until all of those questions are answered. Let me just take one or two final questions for you, Roderick, before we go to that. Let me see here. So one says, is the Information Commissioner above the Jamaica Constabulary Force? Yes.
No, obviously the Jamaica Constabulary Force under the ambit of national security would have clear exemptions and deal with a whole different level of access to information. So that is data privacy and national security, okay? The Information Commissioner, however, think of the Information Commissioner as on the civil side regulating how you deal with data. All right, so I would not say it's above the JCF, but under the purview of this act, we'll have significant powers.
Okay, and one
including enforcement.
one thing. Amishka says, so each time I decide to change a purpose or intent of the data, I must seek consent from the data subject?
Yes.
Good. All right. Nothing clearer than that.
Yes.
Michael Sutherland, I'm not sure if this is a question for you or maybe we should hold this for the tech guys, but how does cloud storage affect compliance with the DPA? Right,
good question. So you have to quickly suggest the answer. It's not an absolute answer, Michael, because obviously there are a number of variables as to cloud storage, where, etc. But what you would be obliged to do is to ensure that wherever your cloud storage ends up, wherever your pot is at the end of your rainbow, that the regime in terms of protecting the data, in terms of processing the data, is in keeping with our DPA. So you do have an obligation to ensure that if you do use cloud storage, there is compliance with the standards under our DPA.
And also Odeon wants you to repeat the entity, which entity the breach should be reported to.
Information Commissioner. In some instances, if you do have a data protection officer, you would first report it to the data protection officer.
Okay. I think we are pretty much out of time for this section. We have quite a few more questions there, but we will certainly get back to you. I do want to move on to the next presentation. Thank you so very much, Roderick.
You're welcome.
What would we do without you? Thank you.
Sure.
As many of them as possible. Good morning. This is coming from Keisha Harriet. I noticed your presentation makes specific reference to customers. Are employees also data subjects and therefore governed by the DPA? I think we had answered that before. The answer to that is yes. Are employees specifically referenced in the DPA, or are there specific reference in the act that deals with employees?
There isn't a specific reference, Anne-Marie, as a data subject. Providing the information, you would be under the Act. The question would be depending on what the information is used for and how it's processed, maybe there's an exemption.
Okay.
But I think it's best to err on the side of caution.
All righty. Yes, the presentation will be made available. It's recorded, so we'll be sending out recordings of this presentation, all three presentations to you. Good morning. Where an organization enjoys immunity, okay, is the individual or perpetrator still found liable under the Act?
So it depends. Potentially, yes. You may enjoy immunity from prosecution under your specific act, but depending on what has happened with the data and what the breach may be, you may not have immunity from breaching the provisions of the Data Protection Act. So it will depend on the situation and the specific type of immunity.
Okay, still on you, Roderick. As a Jamaican-based business, will I be restricted in transacting business with Europe/US organizations if I'm not DPA compliant or GDPR compliant?
You would not be restricted. What you would, however, obviously be is more open to risk if you have not put in the proper policies and infrastructure to ensure that you're compliant both with the DPA and the GDPR and any specific requirements in the US.
Okay. Where a public authority is enabled by other regulation to capture sensitive data, does a public authority still need to seek consent in order to comply with the DPA?
That's a very good question. First, it would really depend on the type of authority and how the data is being provided. But yes, under the DPA, you would require to indicate that you are asking for consent and what the data would be used for.
Okay, moving on down. This is from Rohan. How does this act, I guess that's the DPA, affect the HR department as it relates to resumes or CVs collected?
That actually is a pretty interesting question. So again, one of the questions is, how do you receive that resume or CV? Very often it's sent voluntarily to you. So you don't ask if you don't advertise. A lot of people send their CVs, resumes these days voluntarily. Naturally, there would be implied consent that that information is being shared with you for a particular reason. Really good question. And I think that in the regulations, we may see some more specificity of how you would handle information provided to you where you have not requested it.
All righty. Then Ramoyne wants to know, does government organizations need consent to process your data?
Again, it would depend on the type of organization. There are some organizations you have to provide information with to transact. And I believe the Act does have some exemptions. So it really depends on the entity and the nature of the engagement.
All right, I'm not sure anyone here on the panel can answer this one, but it says here, so each of our executive agencies must have data protection personnel on staff, or will the Jamaican government have a blanket committee?
That's a good question. I don't know that based on the Act currently, yes, each executive agency would be required to have a data protection officer. I don't know that a blanket committee would suffice. Having said that, it is not unusual for a data protection officer to be the data protection officer for more than one entity. So the Act referring to data protection officer doesn't necessarily mean that each person needs to have their unique data protection officer.
Okay. Cherie Simpson wants to know, can the responsibilities of the DPA be shared among team members?
Yes, they can be.
Okay. This is a pretty long one. My name is Emerson Bryan, a Jamaican information management professional living and working in Barbados. One of the biggest challenges I see in terms of the DPA is that of contact tracing for businesses being required to solicit the personal identifying information of persons in largely paper-based processes for COVID-19, and without any provisions for the retention and disposal of this information. As you know, under GDPR, this would be a no-no, and the Jamaican DPA is intended to be compliant with EU rules on data protection. We have looked at vulnerabilities for IT platforms, but what about those in hybrid or paper systems? What's your take on this system as it relates to the Caribbean, given that digital transformation is moving ahead? Yes, but most processes are still in hybrid systems due to legal requirements. Roderick, this sounds like something for you.
Yes, it's a very, very thought-provoking question, very pertinent to the Caribbean. And we looked at the issue in preparing for this presentation. In fact, the Act does not limit the processing of data to digital processing, even though it speaks about automated processing, etc. So Emerson is right. You handling data on a paper-based or hybrid system still brings you under the DPA. And so he raises some very, very important questions, because he's right. We don't yet have the regulations that deal with disposal. And while from the point of view of public health and the various disaster risk management orders that Jamaica has put in place and other countries throughout the world to handle the crisis that is COVID-19, the question becomes, how do you process the data? How do you handle it? And how do you dispose of it? So it's really very important. And I would expect that in the regulations, we will see some more obligations as to how we deal with that. But for right now, Emerson, I think what one would have to do is use one's best judgment, use proper policies, and perhaps follow the GDPR in terms of the guideline of how you would handle that for the time being.
Yeah. All righty. Does the upcoming Data Protection Act include guidance on the data owner's rights to their data access and portability of their data? How do companies make sure they comply with these aspects? Roderick?
Right. So it does provide for the data subject's right to access their data. I'm not sure that it deals with portability specifically, but you can ask the data controller, how are you maintaining my data? And if you're not satisfied, you can make a complaint to the Information Commissioner. So it does provide that in a specific section of the Act.
Let me see here. When does the data become the responsibility of a data controller? Is it once stored by the company or once the information is collected?
Right, it's once the information is collected.
Okay. All righty. Does the Act make provision for any form of DPO certification program?
Good question. Currently it does not. And I don't know that the regulations would specify that. What it does say is that you must ensure that your DPO is adequate to do the job required. So it presumes that the person would have, or entity would have, some amount of training and experience in the space. Obviously, when you're looking at the standards that will obtain under the Data Protection Act, certification of your IT team, the people who will be directly dealing with the obligations under the Act, can only enhance your ability to show the Information Commissioner or your data subjects that in fact you have put in adequate policies and you have adequate systems dealing with handling data.
Question. All righty. I think somebody had asked for us to put up, Brian, if you could put up the last slide in Roderick's presentation, his takeaways. I think it was the last thing that he had said, that he could put those up as, yeah, final takeaways, right? Somebody wanted to see that. But yeah, final takeaways: confirm whether your business needs to comply with the DPA, access your data processing activities and obligations, access your data processing activities and obligations falls under the DPA. Maybe I'm not reading that right.
Whether it falls on.
Oh, whether. Okay.
Whether, correct.
And make sure you have the relevant agreements in place. And of course, develop proper policies and governance. You want to add anything? You want to clarify? Oh, and it can.
There are a few more. I think, Anne-Marie, the point is that you have to educate yourself. You have to assess both your IT infrastructure, the hardware, the agreements you currently have in place, and your internal policies. David made the point in his presentation, very important, that the leadership, both of the private sector and the public bodies that are going to fall under this act, need to step up, and they need to recognize that the obligations and the liability goes right to the top. So it's really important that on a company basis, on an organizational basis, you're not just looking at your IT policy. You're not just looking at your privacy policy. You have to be looking at how do we as a company, as a business, as a public body, handle data? How do we treat this data? How do we treat that data subject? And it has to be right through the organization. It's not simply a minute in a board meeting saying, we've taken advice and the IT controller now has their instructions and we're gone. You have to demonstrate that you are really taking it seriously. And particularly for Najib, for Beasley, for Fraser, Fontaine to assess properly your risk. Your premium will be significantly lower if you're able to demonstrate that throughout your organization, you have looked carefully and comprehensively at how you handle these risks and obligations.
Thank you. And the final question is from Hyacinth. How will the DPA affect companies such as debt collections agencies who may receive data from institutions such as banks?
Good question. It affects those entities directly because when you receive that information, it will contain clearly personal data and in some instances what's qualified as sensitive data. So you will fall under the Act as a data controller and you will have to ensure you have the proper policies and infrastructure in place.